Hello, everybody. Adam Parks here with another episode of Receivables Roundtable. Today, I am here with my friend Nicole Strickler, and she is one of the attorneys or one of the partners over at Messer Strickler. She is a litigation defense attorney protecting the industry, a frequent speaker at just about every conference that I attend, and just an all-around fun person. How you doing today, Nicole?
I'm great, Adam. How are you doing today?
Another day in paradise. Not that there's anybody out there that's not familiar with you if they are active in this industry, but can you tell everybody just a little bit about yourself and kind of how you got to the seat you're in today?
I would love to. Yeah. I actually kind of fell into this industry, which I feel like is kind of what a lot of people do. I don't know that anyone really plans, maybe if you had a family member in the industry and you kind of followed in their footsteps, but that was not me. After law school, I actually got a job as a collection attorney. It was 2009, and the economy had a lot of room and need for collection attorneys back then. And so that's kind of where I started. And from there, after kind of learning the system and a lot of the issues that were, affecting collections, I moved into more of the compliance and defense realm, which is what I've been doing for about the past 12 years or so. But that's how I got my start, was on the ground in the Cook County courts, litigating the credit card debt, right?
Not in an easy location either, right? Like Cook County. That's
yes,
high volume. That's not easy.
Yep. High volume, very specific. Anyone that knows Cook County in Chicago knows that it's very distinct, and they have their own way of doing things, and you have to acclimate. And you have to be a fast mover, and you have to be able to multitask. And but it was basically a great crash course in like civil procedure, and then the issues that we dealt with in credit and collections. And so it made for a really easy, I guess, transition into more of the federal court realm, which is where we see the majority of these claims that I defend now today. So.
Let's talk about that transition from being a collection attorney to going into the defense side and starting your own firm. Tell us a little bit about the firm itself and kind of what you guys are focused on over there.
Sure. So my partner, Joe Messer, he was one of the first to really defend these types of fair collection practices at claims, 30 years ago or whenever that started. And so he had a client base that had started, and I kind of just started growing it from there. It started hitting the conferences and networking and, getting my own client base. And kind of before you knew it, I had a nice little practice established. So in 2016, my firm actually broke off from one of our partners, and we even focused more on the consumer financial litigation services. And then in 2018, we brought on Lauren Burnett as another partner, which expanded our reach down to Florida. So now we have offices in Jacksonville, Sacramento, and Chicago. And then we have some little satellites as well throughout the country, like Kansas City, Missouri, Michigan, which has worked out really well. So, we maintain a national practice in consumer financial services, both on compliance and defense. So we're kind of all over the place, which is nice, and it's diverse. And, I've got cases all the way from California to, I just closed one in Puerto Rico. So you never know where I'll be.
Well, that sounds like a lot of fun. And as somebody who is spending, a lot of time defending the industry, that was kind of what I wanted to talk to you about today was, obviously we've got some new regulations that are coming out. And then I also want to talk a little bit about kind of what's hot right now in terms of defense and what are some of the big ticket items that our audience should be paying attention to in terms of defending themselves or preparing themselves so they don't find themselves in the crosshairs of these lawsuits. But obviously the big topic these days is Reg F, and obviously it's coming very quickly, and we've got an implementation date in place. So I know that as we kind of talked before we started recording today, we talked a little bit about kind of updating the written communications and what that process looks like for a debt buyer, an agency, a law firm. Can you tell us a little bit about what you're seeing and kind of what you're working on from a preparation standpoint to make sure that groups are prepared when this all comes down?
Yeah, absolutely. I mean, I would say that's probably the vast majority of my compliance questions that I get right now. I
Mhm.
kind of serve as a mini general counsel to a lot of my clients that I do a lot of litigation for. And so they come to me when things like this come up. And I'd say that's the number one question is, okay, November's coming. We've got to be ready to switch over to our, new communication formats then.
Mhm.
So people are looking for counsel on how they need to make changes, right? So, generally the initial communication and coming as close to the safe harbor that the CFPB put out as possible is kind of on people's minds. For those of you out there that don't know, CFPB put off a model letter that agencies can use, and if they utilize that form letter, then the whole idea is that they will be insulated from any claims based upon that letter. So it's kind of the CFPB's blessed initial communication. But there are some unique things in there that they are really different than what we'd see in our typical debt collection letter now. The text of the validation notice has changed. The same concepts are there,
Mhm.
but they've moved away from, say, pulling the precise language out of the statute, and instead they tried to make it, I guess, more consumer friendly. They've instituted like a checkbox scenario in the event that the consumer wants to dispute the debt. I think the thought was it would make it a little more understandable and easier in the event that the consumer does decide to dispute. An itemization date that was not present before is now required. So it could be anything from the day of last payment to the charge-off date, something that the consumer can look back to help identify the debt in this and in future communications.
Mhm.
So just kind of revamping that initial notice, I think, has been key to the extent that you can, and I think some clients are finding that they can't exactly model their letters after the safe harbor as much as they'd like to for
Mhm.
varying reasons. So that's kind of been an issue, particularly with my attorney clients and law firm clients, because the template that the CFPB put out for the initial letter is really more geared toward a traditional agency as
Mhm.
opposed to a law firm. So,
Okay.
law firms have state bar requirements that they have to keep with, within their letterhead and, licensing issues. And they might not fit into certain buckets that the CFPB has put in there. The CFPB wants some sort of itemization on there of the debt for those debts that are fluctuating. But if you have a case that's, let's say it's in litigation or was in litigation at some point, everything may not add up necessarily. Like might have a court cost bucket, right, that
Mhm.
needs to be in there. And the CFPB's model notice doesn't have
Include
that
that.
sort of. So these are just some of the issues that I think folks are working through. So I would say the initial communication, and then how to utilize the CFPB's guidance in terms of new communication methods like emails or texts. What needs to be in there, what shouldn't be in there, how much information should be there. People are very interested in the limited content message and
Mhm.
how can they use that? Because unfortunately, the CFPB, really the guidance is based on voicemails alone, as opposed to emails or texts, which initially in the proposed rules, the limited content message was proposed to apply to all three. Now the final rule says, actually, we're just going to have for voicemails. So I'm having a lot of conversations about how they can still utilize that in their business and perhaps still make a limited content argument. So a lot of processes changes, Adam,
Sounds
a
like it's
lot
the
of,
communication itself and also the strategies by which these communications are being provided. So we have to concern ourselves with what are we saying, but then how are we saying it? When are we saying it? Right. The limitation on call caps or communication
Right.
caps and other things. And how do you then operationalize that type of information? Like that seems to be, I mean, that's what I'm hearing is the big challenge here, based on what you're saying is that how do we then operationalize this? Like we now know that we have to change these letters and we have to engage attorneys and others to get that piece together. But then how are we modifying our internal systems to make sure that we are meeting these compliance requirements and not letting things run off the track, so to speak?
I've been having some interesting conversations with clients on that exact point. So obviously, one of the first thing you're going to want to do is try to modify your compliance manual out there, your written procedures that you can, rely back on and that you use to change your staff. And talking through a lot of this with clients and the alterations they make, and even the processes that they have in place, it was surprising to me that a lot of good things that my clients were doing were not being actually put in writing in the manual, which I think is a lost opportunity for folks out there. Why not have that documented in there and have like this great fully comprehensive thing to put together that you can point back to in case there's a problem.
And you don't want to have to do that on the fly. And it was my experience when we started Compliarm and started writing policy and procedure for agencies, debt buyers, law firms, and helping them to look at from an operational standpoint how they were going to document that stuff. If you don't do it up front, like you're never going to get it done. But the question becomes, why not get it done? Because each new person that comes into your organization, whether it be a new employee, a regulator, an examiner, whatever, having this documented is an opportunity, but it's also an opportunity to improve your overall operations, because when you write it down, you start to identify the holes, right? It's great to think about it. It's great to whiteboard it, but when you actually formalize that documentation, it's amazing what you can find.
Yeah. And and that you can subsequently use that to protect yourself in the future is just an added bonus. I'll give you a perfect example. I mean, I was reading a case today from one of the industry publications that was published out of the 10th Circuit, right? And the whole case was about the fact that the agency had placed one call after receipt of a cease and desist. One call. That was it. And it was because of a lag time in processing, which, those of us out there that are familiar with the industry know just with the amount of volume and mail and email and whatnot, sometimes it can take some time just to process and get through those things, right?
Sure.
And the 10th Circuit just really nailed the agency. And part of the problem was they weren't able to point back to anything in writing in their manual. And they were very critical. It was, it was a little sad for me to see because, just as defense counsel and just, having litigated so many of these bona fide error cases, you could see that the agency was trying to do the right thing and that they had some type of process in place, but because it wasn't delineated effectively, and they didn't have the evidence to point back to, they lost. And that's an expensive loss. And all the way to the appellate court back, it's not something that I would want to have to explain to my client down the line, right? So,
Sure.
I think with Reg F, it just gives us another opportunity to go back and take a look at the things that, we could improve on.
So beyond kind of the Reg F situations, what else are you guys seeing out there in terms of kind of big ticket lawsuits that are coming down the pipe that people should, have in the back of their mind or be preparing for, or even considering as they're going through the Reg F process?
Sure. I would say the biggest thing I see, which I call the more dangerous cases, are involving reasonable investigation into disputes. Mostly Fair Credit Reporting Act related cases, but just also generalized identity theft claims. Those are the ones that I think consumer attorneys are more interested in because they can have a better chance of substantiating some actual damage, right? Which is a big concept in terms of right. And so enabling staff to be able to properly investigate the claims, giving them the tools that they need to do that. Some things that I actually have run into recently that I think are interesting is sometimes a collector's attempt to prevent third parties from getting information actually stands in the way of investigating these types of wrong person, wrong party claims. Because the collector can't verify who's on the call, it won't provide information. And so the communications don't stop and it's a snowball effect. I've seen those happen a couple times, and then you're in a situation where, perhaps, you're pursuing the wrong person with a similar name for the debt. And even that, can end up in a collection lawsuit. I've seen that happen too. And then we're in real trouble. So, those are some of the other things I'm seeing, or, just, generalized service of process issues have come up recently. I've seen a lot of attacks on service of process from cases that originated like 5 or 6 years ago, where people were served and there were defaults and now they come back out of the woodwork.
Weird.
That's something I know. Yeah. Well, for those of us that, litigated collection lawsuits, it's sometimes it's difficult to find that process server from 5 or 6 years ago who had, the affidavit of service of process if you get a legit challenge.
Yeah.
So those can be difficult as well. But, those are just kind of some of the things that we're seeing. And I know you and I talked about Hunstein. Of course, we've seen lots of those. I think everyone
I haven't seen any
tired
videos
of those. Yeah. So, that's kind of the gist. But I think, just circling back is, putting those policies and procedures in place, helps with all the things I just mentioned, not only the Reg F prep, but policies on reasonable investigation and identifying the correct consumer, dealing with identity theft. Those are all things that, the better your policies are, the better your process is, the less risk you have, right? So
it sounds like the giant web of rules, regulations, laws, and expectations from the consumer are continuing to create this cloudy web, for lack of a better term, of requirements that we now have to continue to dig through. I think the changes with Reg F, there's definitely some things that are beneficial to the overall economy, or beneficial to the consumer. I think it does create some operational challenges. Obviously, it creates some legal challenges, and fortunately, I feel like we've gotten some notice here and have had an opportunity to start to put some of these things together. But it never hurts to get someone like your perspective, who's on the front lines, kind of fighting these battles in the courts, versus the guys like me that are sitting in the background, playing on a computer and trying to resolve these issues in some way, shape, or form. So, I really can't thank you enough for taking the time to jump on and chat with me today. I'm hoping that you and I can continue to have some of these conversations into the future, because you have some really great insight into what is happening across this industry. And I really appreciate that.
Well, thanks. And I appreciate being here. It's always fun to chat with like-minded folks. And, it's that's how we get better at what we do, right? As we get different people's perspectives and we learn from each other.
Exactly. I feel like I learn from every conversation I get to have with you, whether it be at a conference, over the phone, in a video chat. There's always something for me to pick up and learn. So I really appreciate that. For those of you that are watching, if you have any questions that you'd like to have answered, feel free to leave some questions below. Both Nicole and I will be responding to those on LinkedIn and YouTube. If you have any additional topics that you'd like to see us discuss, or guests that you'd like to see me interview, feel free to leave those comments below as well. We're always looking to create new and better content for the industry, by the industry. And for those of you watching from home, thank you so much. We will see you again soon. And Nicole, I hope I get to see you at another conference before the end of the year, and something tells me that'll happen.
Probably will.
Thank you again so much for your time, and I look forward to seeing you again soon.
Thanks.